Welcome to today's webinar on the legal issues arising from the failure of SVB and Signature Bank. I'm Jeff Taft. I'm one of the leads of our financial services regulatory practice at Mayer Brown, and I'm in the DC office. I'm joined by a number of my colleagues again today. This is the second of a three-part series that we are doing to help clients and others understand what's going on in the marketplace. If you were able to join on Monday, you heard us give an overview of what's transpired to date. We've talked about the political response to what's transpired. We've also provided a little bit of the ECVC perspective on that call. Talked about some of the disruption in the loan market that's occurring in the syndicated loan market. Some of the implications in the UK and the sale of SVB UK. And we also talked about implications potentially for the holding company of SVB. So if you didn't get a chance to dial in yesterday, that was recorded and it's available on our website along with our resource page. Before we get going today, I do want to give a couple of the standard disclaimers that you heard yesterday. The views of the panelists are the views on the current market and are not meant to reflect legal advice. In addition, to the extent members of the press are listening today, we remind you that there are matters discussed here today are not considered for publication or attribution without Mayer Brown's or the panelists' express consent. Members of the press should contact Stacy Berkowitz if they want to follow up with questions or have discussions with anyone on the panel or anybody else at Mayer Brown about these issues. If you have questions during the panel today, please type them into the chat. We'll try to address them either at the end of the program today or some of them potentially tomorrow during the program. I admit we had between 40 and 50 questions yesterday. We did not get through all of them. I think we tried to cover as many as possible, and we'll try to do the same thing today. So starting today, I want to kick it off with Matt Bazance, who's going to talk about the bank term funding program that was put in place by the Fed that's designed to shore up the banking system. Once Matt goes through that, we'll go through a group of other folks we have on the line to cover other issues. So Matt, do you want to kick us off?
Sure. Thank you very much, Jeff. And thank you to our listeners. My name, as Jeff says, Matt Bazance. I'm a bank regulatory partner in the firm's DC office. And I think it's been interesting looking at this because rightly, much of the focus to date has been on the two banks that failed, Signature Bank and Silicon Valley Bank. But there are 4,800 other banks in the banking system, and they do have a role to play. And the Federal Reserve has realized that some of the problems, while idiosyncratic to the two failed institutions, there are broader economic trends related to the valuation of long-term government bonds as well as mortgage-backed securities, that those have been declining in value with increasing interest rates. And so the question is, how does the Federal Reserve provide some measure of support for banks that have those types of instruments, because they also could come under pressure either from marking their holdings to market, or if they had to sell their instruments on an expedited basis in order to meet customer demands. And so both of those are problems. Both of those are significant problems, but the Federal Reserve has designed a program that it believes will address these, and that is the Bank Term Funding Program. The Bank Term Funding Program is very similar to the COVID-19 facilities that we saw a couple of years ago. And it is structured in some ways similar to the discount window, although as I'll discuss there are some important distinctions. And so the Bank Term Funding Program will be made available to depository institutions that qualify for primary credit in with the Federal Reserve. And so that's broadly most insured depository institutions, that is U.S. branches and agencies of foreign banks, but non-depository institutions will not qualify. Depository institutions that are only eligible for secondary credit will not qualify. It's only those that are eligible for primary credit. And this reflects part of the issue that the Federal Reserve generally cannot lend to an insolvent institution. But it can lend to pretty much any other institution that is not insolvent. And so that is a guardrail by saying that they're tying it to primary credit eligibility of a depository institution. The Federal Reserve is putting in place a limiting principle. You do not need to have a master account at the Federal Reserve in order to obtain from the bank term funding program. You can, if you are a depository institution otherwise eligible and you don't have a master account, you can go through a correspondent account at another depository institution that does have a master account with the Federal Reserve. So you can go on an indirect basis like that. And what will you do? Well, you will be allowed to place certain qualifying assets, again, long dated types of bonds, other types of debt securities that otherwise would be eligible to pledge to the Federal Reserve, that you can place those into the term facility and receive from an advance from the Federal Reserve. And you might say, well, Matt, why wouldn't I just pledge them at the discount window then? If you're telling me that it's the same types of eligibility criteria, why wouldn't I just pledge them? And that's because the rate that you will be required to pay is different. It is a fixed rate based on the overnight rate plus a very small percentage. And so it will not vary over time. Whereas with primary credit, it would vary depending on if the Federal Reserve changes the primary credit rate. More importantly, however, you will get, when an institution pledges at the discount window, there are various haircuts that are assigned to collateral based on its market value, based on its liquidity, et cetera. And under the bank term funding program, the Federal Reserve will advance you par value for the instruments that you are putting into it. And so if you have a long dated treasury that has declined in value, the market price may be 80, but the Federal Reserve will pay you the 100 par for it in the term funding program. And this is, again, in recognition that there is not a concern that the government will pay off 100% of the bond in 20 years, or that a mortgage-backed security will pay off 100% of the security in 30 years. But given the pricing and the interest rate environment, this is a problem. And that's what this is intended to address on a liquidity basis. The program will run for 1 year, at which point, hopefully, this will be either have been addressed by a long-term solution, or a long-term solution will not be needed. And if you are a depository institution, you can pledge this to the Fed at any to the new term funding facility at any point over that year. However, it must be with respect to an asset that the depository institution owned on March 12th, 2023. This is important because it's not as if you can go out into the markets and buy a bunch of bonds at 80, 90 cents on the dollar, buy a ton of mortgage-backed securities that have declined in value, and then put them to the Fed and effectively get a windfall. That it has to be assets that the depository institution owned on March 12th, 2023. And the purpose of this is to ensure that that people aren't gaming the system. One question that we've seen, and we don't have a good answer to it yet, is what about assets held at affiliates? What if I had something in an SPV? What if I had something in a mortgage company? It was something that I wholly owned. What if I had something in a broker dealer affiliate? It was an asset that I wholly owned in my group on the 12th, but I've since transferred it to my bank because my bank is the only part that can access the facility from the Federal Reserve. That question of how affiliate holdings will be addressed has not been addressed by the Federal Reserve. And so I think that's something we're looking forward to getting some clarity on. There's also some logistics, and the Fed has said they will be very similar in the logistics to what they did with the COVID facilities, that it will be, again, effectively retroactive back to the 12th. So if people are struggling to get on the system, set up correspondent relationships, that really isn't something you have to worry about. That will be handled, this is also for the Fed's purposes, they're most concerned with a bank status at quarter end. On a day-to-day basis, liquidity is important, but it is not the only factor. Jeff, if you have other commentary, I'm sure people would appreciate it, but those are the high points of the new bank term funding facility.
Thanks, Matt. Appreciate those comments and the kind of the summary of the facility, and we may come back and revisit that at a later date as well. I think the facility, as we talked about yesterday, does a couple of things. First of all, it does provide liquidity to other institutions, and it does allow them hopefully to kind of meet their obligations as they come due and pledge assets rather than fire selling them into the market. But the second thing I think it does is it's intended to provide confidence to the public that banks are here to stay. There's not going to be a bunch of bank failures. And really that's important, obviously, because bank failures can obviously become self-fulfilling prophecies. If depositors all believe the bank is going to fail and all pull out their money, the bank is left in a very precarious situation, having used that money to make long-term loans and held, 8 or 10% aside as for capital. So I think the facility is designed obviously to shore up banks' balance sheets, but also to give confidence to depositors and to other people that there is in fact going to be some backstop from the government, some help from the government, so that we don't have this issue recurring for the next couple of weeks or months. So I think that's two things to kind of keep in mind about the program. Next, I think I want to kick it over to Megan, and Megan spoke yesterday about playbooks and the ability to have a corporate playbook. So I turn it back over to her and Larry Cunningham. We're going to talk a little bit about that issue.
Great. Thanks, Jeff. I'm Megan Webster. I'm a partner here at Mayer Brown, and I'm fortunate to clients to help navigate through regulatory compliance, transactional, and complex litigation matters. And often those matters are in cross-discipline areas, just like this one. But I have a particular expertise in financial institutions and other highly regulated industries. As Jeff said, I spoke yesterday regarding a few of the lessons we've learned. Among those is the need to have a playbook in place to help navigate issues, not just when there's a failed bank issue, but emergencies and issues that could face an entity. These really include the need to assemble that nimble internal team and external team of trusted advisors. Depending on what events impact organizations, these playbooks potentially include board, securities, and other executive disclosures, evaluation of potential risks, and also reevaluation of what your key risk indicators look like, and also what your risk taxonomies look like, and then how to plan and mitigate those risks. The playbooks also generally include internal and external communication plans, and importantly, the need for counsel to be involved to protect privilege where it's possible. In a second, we'll dive into some of the disclosure and other corporate considerations and have our colleague Larry Cunningham here speak with everyone. The other lesson learned that we think that is really important is the need to review treasury management plans and risks. So those entities that banked with a single institution were left over the weekend really looking for access to credit and other remedies before the news on Sunday hit. So our colleagues in our finance team and other teams really help our clients look at their treasury management plans and help to plan what those credit lines look like. So those are just two quick lessons learned. We'll dive into a couple other ones during the presentation here, but Larry, over to you to speak with some of the corporate considerations that customers of financial institutions should be considering.
Thank you very much, Megan and Jeff. I do want to address corporate governance, just some nuts and bolts with highlights for companies facing uncertainty, both from the current environment and more generally. Several of us produced a lengthier report of this sort that we published on the Mayer Brown website over the weekend. There's a link on the screen. You can find it on the Mayer Brown website. And I just want to highlight a few of the many topics that we covered there listed on the screen. General perspective, the duties, standards of review, potential claimants, oversight duties, and then the special attention to officers' duties. Companies will be affected by failed banks in a lot of different ways. Some will face their own liquidity or solvency challenges. They will sometimes be forced into making difficult decisions, particularly prioritizing limited cash, and board oversight will often be implicated in these cases. We have seen, and we encourage executives of companies in such situations to open a dialogue with their boards of directors, particularly independent leads or chairs and audit committee members, and to coordinate with both their general counsel and outside counsel as needed to assure compliance with governance duties as well as disclosure duties. A little refresher on directors' duties is useful, and this is particularly useful in times like this because decisions are often made under pressure and are subject to heightened scrutiny and second guessing by a variety of stakeholders, particularly decisions to prioritize uses of limited cash, to raise capital, thinking about strategic alternatives, or deciding not to pursue any of these alternative ideas. So the two basic duties all directors owe are the duty of care and the duty of loyalty. The duty of care requires acting in an informed, considered manner. So directors must inform themselves of all material information, carefully consider that information as well as alternatives, and then act carefully. In doing so, they are entitled to rely on the advice of officers of the company as well as outside advisors, but it's best practice to make independent evaluations of assumptions and information presented. The duty of loyalty requires directors to act in good faith and in a manner they reasonably believe is in the best interests of the corporation. Directors must act as independent, disinterested participants. They cannot act for their own personal, non-corporate purposes, such as to protect their position or any parochial position. And if they have a conflict, they should immediately alert their colleagues on the board so that it can be neutralized if feasible. Standards of review: if someone challenges directors' decisions, well, those that are made in accordance with the care and loyalty I just referred to get the benefit of the business judgment rule. This is a standard of extreme deference that judges give to boards who faithfully discharge their duties of care and loyalty. But in cases of conflict of interest, self-dealing, lack of good faith, and other imperfections, judges apply a more onerous, entire fairness standard that puts the burden on the board to show that their decision was fair, both in substance and in procedure. And given that decisions made in environments like this will likely attract second guessing and scrutiny, having a mindset of expecting that entire fairness scrutiny may be prudent. Potential claimants: for most companies who are operating in the ordinary course of business, the boards owes their duties to the corporation and its shareholders, and the shareholders would be the group entitled to sue for breach. But a company that is insolvent may also be sued by the creditors of the company. They would also have standing to sue. And so at that stage, the director's duty shifts and becomes not just focused on the shareholders, but on all of the constituents. Now, since it's not always easy to tell at what moment, if any, a company becomes insolvent, again, when operating in a situation of financial uncertainty, it's wise for directors to imagine that they're going to face claims from a variety of constituents and therefore try to act in the best interest of the overall corporation. Important to appreciate are the oversight duties that come out of the basic duties. Boards are responsible for assuring that management maintains an effective system of internal control and information and risk management. Directors are not responsible for executing that on a daily basis, but they are required to assure that management maintains such a system. And emphasize here, the case law in this area continues to evolve, and the tendency seems to be to expand the scope and intensity of this obligation. And again, in times of uncertainty, erring on the side of caution is probably prudent. And finally, a note on officers' duties. I've spent most of these minutes talking about directors' duties. Officers' duties are usually described generally in a company's bylaws and then detailed in their employment agreements. But in general, they have the same duties as directors have: the duty of care, the duty of loyalty, the duty of oversight, tailored to their particular scope of authority. And so in trying circumstances, when officers are making difficult decisions, it's probably prudent for them to consult with senior officers up the chain, and ultimately for CEOs and CFOs to consult with boards of directors. But that's our general rundown. Again, you can read the far more detailed elaboration of these points on the Mayor Brown website. We also have a blog that we use to discuss board responsibilities in a more general way. And there are some of the recent posts. So thank you very much, Jeff. I'll turn it back to you.
Thank you, Larry. Very interesting. And I think, and every time you see a bank insolvency, there's all sorts of, tricky issues that come up, especially with respect to the holding company. The holding company directors have a duty to the holding company, but the holding company also has a legal obligation in many circumstances to serve as a source of strength for the depository institution. Sometimes serving as a source of strength for the depository institution, may allow you to run contrary or may ask you to do things that are contrary to the interests of the holding company. So we see those issues come up a lot of times in distressed situations where the holding company directors are kind of put in that circumstance. So very good information to kind of keep in mind. With that, I think I'm going to turn it over to Aaron, who's going to cover some of the developments in the lending market. We talked a little bit about this yesterday, but I think there's a lot going on and there's a lot to kind of keep in mind here. Aaron?
Thanks, Jeff. Thanks, Larry, and thank you all for joining. So we talked yesterday, as Jeff was mentioning, a bit of what our focus has been on here in the restructuring practice and the lending practice, and in particular supporting clients who are counterparties to SVB and Signature Bank, and really understanding the changing landscape. And that's really continued today as developments have continued. For lender clients in particular, we've really spent a considerable amount of time on questions relating to defaulting lenders under the governing credit agreements and how that has shifted even in the last several days that we've gone to bridge banks, and the FDIC has put out additional guidance even in the last couple of hours, treatment of qualified financial contracts within those bridge banks. And so on those questions, while banks like SVB and Signature cannot become debtors, they are not eligible to be debtors under the bankruptcy code. A lot of the relevant provisions governing the FDIC's actions here under the relevant regulations and the FDIA are borrowed from the bankruptcy code. So on interpretive questions, of which unsurprisingly there's a lot, we've been teaming with colleagues both on this call and off to work through those issues. And again, defaulting lender and qualified financial contracts are probably two of the most obvious. Turning to sort of something flagged by both Larry and Jeff, bank holding companies are eligible to become debtors. And so there has been a lot of, or some of the focus is shifting to that now, in particular on the SVB front, which has a bank holding company, SVB Financial Group. We're in a bit of a holding pattern, no pun intended, to see what happens. There does seem to be some market speculation that the SVB Financial Group is going to be able to sell some of its other business segments beyond the bank. It has an asset management arm, a private wealth business, a securities business. It's not yet clear how those transactions are going to be effectuated, whether it's inside a bankruptcy filing, outside of a bankruptcy, and then even within a bankruptcy, whether it's as part of an asset sale under 363 of the bankruptcy code, or maybe through a Chapter 11 plan. But either way, there's just growing rumblings about an SVB Financial Group filing. Again, not unexpected. We understand that they've hired executives who were very involved with the Washington Mutual collapse from several years ago, which did involve a holding company bankruptcy. They've hired financial advisors, they've hired legal counsel, and so a filing does seem imminent. And so just to highlight some of the issues that folks are starting to think about on that front, assuming that SVB Financial Group does go into Chapter 11, the biggest issue I think we can expect to see, and probably manifested in several different ways, are disputes between creditors and equity holders of the holding company, again, to the point that Larry and Jeff were just touching upon, and the FDIC. It's going to be fights over priority to those assets and the proceeds of those assets. In that regard, front and center is likely to be to what degree the holding company has been already pre-bankruptcy required to commit under its source of strength obligations to SVB. So as folks might be familiar, one of the strongest rights, one of the most unique rights that a company has once it has filed for bankruptcy is that it can reject a lot of its contracts. It can reject a lot of its obligations. One of the key things in a bank holding company bankruptcy, though, is that the SVB Financial Group here, for example, under 365(0) of the bankruptcy code, it would not be able to reject a defined commitment to maintain the capital of SVB. That kind of commitment would automatically be deemed to be assumed, and it would need to be cured, meaning the commitments would have to be honored on the threat of otherwise a Chapter 7 liquidation. If for some reason the holding company could not satisfy those obligations, they wouldn't be able to restructure. And so those commitments also have priority over other creditors. The FDIC, again, is going to be the beneficiary of those commitments. And so there's likely to be, or there's the potential for disputes over what and whether the holding company has made those commitments. It was an area of dispute during the financial crisis. One of the better known cases on the topic is the Colonial Bank Group case. There was a dispute. The FDIC claimed that there was a commitment to maintain the capital of the bank in that case. The holding company claimed there was not. It was more amorphous than that. And actually, the court in that case came down on the side of the holding company. And so the FDIC was not able to take priority over the creditors. And so you could see it's a huge issue depending on how big those commitments were, what the assets are going to be. Similar sort of area dispute is likely to be tax refunds. There will likely be a debate. It will depend on whether there's a tax sharing agreement between the various SVB entities. Assuming there is not, there will be a debate or a dispute between whether the tax refunds, assuming there are some, should be left with the bank and the FDIC because it's presumably the bank's losses generating those refunds, or perhaps should it be the holding company will have the revenues to take advantage of those losses. And so those kinds of things where, again, early days here still, but disputes between the FDIC and other creditors of the SVB corporate family are likely to pop up. If and when there is a filing, I'm sure we'll be back out with other webinars and happy to discuss with folks. But again, just at least wanted to start flagging those issues. It does seem like it's coming down the pike. And so lots of things still in flux, but definitely issues that the industry is starting to think about. So I'll turn it back over to Jeff, and I think we're going to open it to Q&A.
Yeah, a couple of quick points, and thanks, Aaron. That was very informative, and I think that is an issue that's going to play itself out in the next week or so, probably. As Aaron alluded, there is a statutory obligation for bank holding companies to serve as a source of strength. There had always been that obligation, either in regulation or in theory, which had been litigated throughout time, going back to the M Corp case in the 80s. But Dodd-Frank put that into the statute and created that explicit obligation. So I think that's obviously what Aaron's alluding to, and whether that is something that the FDIC had made some sort of a demand there. Colonial, there was a predated written agreement where they was agreeing to provide certain amount of capital. So there was at least an agreement that they could point to in that case, a written agreement that the holding company had agreed to. So the facts will obviously matter, and as it plays out, we'll have to look at those facts and see how they are apparent here. Before we get into the Q&A, there was one other development. So this is on the walk-in items. We had the FDIC release guidance today. Their guidance FIL 10/2023, which is basically the financial institutions are required to meet contractual obligations with bridge banks. I don't think this addresses everybody's questions about what the bridge bank's obligations are, but I think it makes it crystal clear that the FDIC views these bridge banks as separate, obviously separate entities who have legal obligations under contracts, and that they will perform. That is every indication that both of these bridge banks, Silicon Valley Bridge Bank and Signature Bridge Bank, are in business. They're going to meet their contractual obligations. They're not going to become defaulting lenders. They're going to make their obligations and they're going to honor their contracts. And what the FDIC is saying in the release, and you can obviously find it on the website, and hopefully we'll have it up on our resource page soon, is that you need to meet your obligations. So if you're a vendor or a service provider, you need to continue to provide those services pursuant to that contract, which was transferred from the bank in the receivership to the bridge bank, and you are still obligated to meet that contract with the bridge bank. The fact that the original contracting party went into a receivership does not give you some sort of an ipso facto clause right to terminate that contract. You have to continue to perform. And I think this is very consistent with, obviously, the purpose for the bridge banks. They've been put in place to preserve the value of a going concern so that the FDIC can sell them off down the road to one or two different bidders who would be buying these institutions. The FDIC obviously realized that the value of these institutions needed to be maintained by continuing them to operate business as usual. And that's exactly how they're going to operate. So whether you can terminate the bridge bank or not, the bridge bank's not likely to default on its obligations. So there's not likely to be any default. But if they do, then you may have contractual rights, and those rights probably aren't going to be subject to any sort of stay, but that also requires the bridge bank to default on its obligations, which we would not expect them to do. They have the full faith and backing of the FDIC and the federal government. They're probably the most well-capitalized banks at this point, so we would expect them to meet all their obligations. So I just wanted to mention that because that's kind of a late development this afternoon. You can kind of take a look at it. I went through it at a very high level, but with that, maybe Megan will kind of turn it back for some questions.
Yeah, thanks, Jeff. I think just one thing for those who couldn't join us yesterday and those on the phone who are not as steeped into bank regulatory issues as we are, can you talk a little bit about the receivership as opposed to the bridge bank? Can you talk about the interplay with those?
Sure. So when Silicon Valley Bank failed on Friday, they created what we think of as, it's called the Depository Institution National Bank, a DIMB, which basically was set up to hold the insured deposits from Silicon Valley Bank. DIMBs don't really hold other assets. They're just there to give consumers access to their insured depository funds so that on Monday they can go in and withdraw money. They can use their debit cards and the like. So the view of the FDIC over the weekend obviously was that Silicon Valley Bank wouldn't extend any credit. They would basically kind of try to sell those loans, but they weren't going to do anything. They weren't going to be in business. They were winding it down. Over the weekend, they did not get the bids they wanted, obviously, for the bank. So they decided to set up a bridge bank. They set up a bridge bank for Silicon Valley Bank early on Monday morning. And basically a bridge bank is the recipient of large parts of the failed bank's assets. They leave a number of things in the failed bank, but they transfer substantially all of the assets, and all of the deposits go into that bridge bank. And there's a bridge bank, obviously, was set up also for Signature Bank on Sunday. And those bridge banks are not banks in receivership. They have their own management, they have new management, and they will operate that bank until it is sold off or until it is wound down. So they are real institutions, they are real counterparties. The only difference is that they received all of their assets from a bank that failed and is in receivership. And the assets that are typically left in the receivership are things like, debt and things of that nature, right? So things that don't have value, so they're kind of carved out. And that's kind of the difference, I guess, Megan, hopefully to gives people some background and some perspective on kind of what the bridge banks are and why they're different. They're different legal entities than the banks that failed. They have very similar names except for the word bridge in them. But they are functioning just like insured depository institutions, and they function just like insured depository institutions.
And the assets of the bridge bank are cleared of any impairments that come over. So it's the clean slate, if you will.
It's a very good point, because the FDIC, when you take from the FDIC, you typically are taking as a holder in due course. So you don't necessarily have to worry about other things that could be undermining your title or your claim to any of the assets that you purchased. The FDIC basically is able to give you effectively clean title to things. So that's another good point.
Yeah, the other aspect is by keeping the doors open, we got a question of we thought that the FDIC are simply anybody else in the government simply tried to keep the two banks in business in order to try and sell a going business and make sure everyone's repaying their loans. Just thoughts on that. I can talk about the auction that was going on, but do you want to sort of touch base on what the future might look like?
I think ultimately the FDIC's goal is to recover as much money from the assets of the failed bank. They do so in order to minimize the losses to the deposit insurance fund effectively. If the deposit insurance fund suffers losses, obviously that could require assessments on other institutions who have deposit insurance. Deposit insurance has to be maintained at a certain level, and when it drops below that level, there are assessments. The FDIC earlier this year, towards the end of last year, had basically come up with a plan over the next couple of years to increase assessments to basically offset what they thought was going to be a deficit in the fund. Ultimately, depending upon how these two insolvencies play out, they could also increase the losses to the fund, and the fund would have to go out. The way the FDIC, though, addresses that issue in a failure is they go out and they try to maximize the returns. Typically, when a bank fails, they're looking for a buyer even before the bank goes into receivership. In either of these cases, I don't think there was enough time for that to go out. So typically when a bank fails on Friday, they announce that there's been a purchase and assumption transaction with another insured depository institution. And that institution will operate the business on Monday. When they can't do that, though, they set up bridge banks, and the bridge banks are designed to kind of keep the going value concern, the franchise concern, and keep that value so that somebody can come in and buy that institution, all designed to kind of maximize the return the FDIC gets from the sale of those assets. It's the FDIC who benefits from the sale effectively of the bridge bank, although obviously they have to make certain payments and things like that. So it's not as if they are the true beneficiaries, but there's going to be a huge gap, obviously, because of the deposit insurance and the need to make them whole for those deposits.
Thanks, Jeff. Can you talk about, or we can launch this to one of our colleagues, perhaps discussing, obviously there was a letter put out by the FDIC that all the deposits and obligations have been moved to the bridge bank, including the QFCs. We got a question whether or not it's fair to assume that clients that have derivative positions with SVB are now at the bridge bank, and whether we expect SVB to continue to perform and what impact that might have on ISDAs. So perhaps we can just talk about that generally for a second.
Sure. So I guess, first of all, qualified financial contracts include derivatives, securities contracts, and other things that are derivatives like. It's a long definition, obviously, but QFCs get special treatment under both the Federal Deposit Insurance Act in the receivership of a bank, just as they do for protected contracts under the bankruptcy code. So what happens in the FDIC world is when an institution fails, the FDIC effectively has until 5 p.m. the following business day from the date of failure, to effectively transfer those qualified financial contracts. And they basically have to transfer all of the related contracts. That can't be cherry picking or anything like that. So they have to transfer all those contracts by 5 p.m. If they do transfer those contracts by 5 p.m. that day to another institution, then any ability that the counterparties had to terminate those contracts by virtue of an ipso facto clause effectively goes away. So in the case of Silicon Valley Bank and in the case of Signature Bank, the FDIC has publicly stated that they've transferred all of the QFCs of both of those banks to the respective bridge banks. Therefore, counterparties do not have the ability to terminate based solely on the fact that there was an ipso facto violation, i.e. the institution went into receivership. Now, on a go-forward basis, if the counterparty, i.e. the bridge bank, doesn't perform, then that may give you grounds or means to basically terminate that agreement. But again, I think transferring them was consistent with trying to maintain the value and the going concern. And it's something that's somewhat unique. The 5 p.m. transfer window is somewhat unique in the FDIA, but the concept of protected contracts getting special treatment, and Aaron or someone can talk about that under the code, really isn't that different. That's something that's accorded to them, whether it's under the bankruptcy code or under the FDIA or other receivership regimes for other types of institutions. Same thing with respect to Fannie and Freddie. There's QFC provisions and the FHFA's receivership provisions.
Great. Aaron, anything to add to that?
No, I mean, other than confirmed, yeah, I mean, they really do track a lot of what's in the bankruptcy code as well. And so not surprised to hear that that's what's being affected here under the receivership provisions too.
Jeff, we're getting a bunch of questions about additional termination events under an ISDA during receivership.
Yeah, I'll address the question a little bit more broadly than that, I think. I mean, there's been some question about ability to terminate based upon the fact that the bridge bank, let's just list a host of things, doesn't have a rating, doesn't have certain amount of capital, isn't potentially well capitalized. I think there are a lot of triggers that potentially, you look at the bridge bank, you look at its balance sheet and say, geez, it's not rated. It hasn't been around for 5 years. It doesn't have assets or capital of X or Y. It's no longer eligible. It doesn't meet the requirements. And this is not only a derivatives question, but it comes up in a lot of other space. I just don't think that one can look at the bridge bank like that in that regard. Say that they don't have a rating, so therefore they're ineligible and you're going to close out your position. I think that has some concerns around it. And again, it's a contractual obligation that may exist in a number of types of contracts, whether they're an eligible depository institution, whether they're eligible counterparty. And I think all those things have to be considered in light of what the bridge bank is, why it was set up, and really whether that's a bona fide reason to be closing out a position with that institution simply because they haven't been around for a long enough time or they don't have a public rating.
Yeah, agree. Getting a lot of questions about what potentially in terms of actions the FDIC could take or other supervisory aspects that will go into looking at what happened to these two banks and the potential impact on management at the failed banks, such as clawbacks. We can either touch on that today or save it for tomorrow.
Well, I think it's going to be an issue that's certainly going to come up. I mean, obviously, I'll just give the basic, and then we can probably tee it up for tomorrow maybe. But obviously, when the FDIC steps into the shoes of the bank, they step into the claims that the bank may have against officers, directors, accounting firms, law firms. And these are typically the types of lawsuits one may see arising out of a receivership or out of a failure of a bank. The FDIC is obviously going to look very carefully at why the bank failed. If there's concerns about accounting or legal advice they got, they could certainly come after both the accounting firm or the law firms. There's certainly grounds under the FDIA for them to do that. Obviously, they're stepping into the shoes of the bank anyway, so they have that right. Law firms and others and insiders are institution-affiliated parties. They can be subject to FDIC enforcement actions. they can be banned from the business of banking based upon their conduct at the institution. So there's a lot of issues. I mean, we have a long way to go with some of those, but I do think you have to start thinking about whether there are going to be those types of claims that are being brought. The FDIC may look at and see whether there were insider transactions, may try to undo some of those. They may try to claw back on bonuses and things like that at the bank. I understand that bonuses were paid out this month, so that could be something that could attract the attention of the regulators. So I think these are all issues that are all open issues. They've come up in a number of other bank receiverships, and the FDIC has a lot of experience in going after parties who they believe were responsible for the institution failing.
Yeah, I think one of the things that if people aren't deeply in bank regulatory is the understanding of confidential supervisory information. It's more fun for me just to be able to ask you the questions, Jeff, than answer them. But can we give everybody a quick overview of what CSI is and just why not all information is public? And I think it'll help those who are not in the banking world day in and day out know a little bit about why all information is not public at the moment.
So obviously there's a lot of discussion and exchange between banks and their regulators, bank holding companies and their regulators. Examinations are one example of confidential supervisory information. Examination reports typically are the property of the banking regulators. They are shared obviously with the regulated institution, but those reports belong to the regulator and they cannot be shared with the public or typically with third parties outside of maybe lawyers and others who are working for the depository institution. So if there were any agreements or any supervisory agreements, or there were any things in the examination reports, that wouldn't be public information. And that is something that's most likely not going to make its way into the public view. Although anybody who is investigating any report that's being done by Congress, I think they're going to obviously consider that type of information. Oftentimes in bank failures, and that very well may not be the case here, there is something in the exam report that gave some inclination that there were problems or there were things going on. There may have been things that officers and directors were supposed to do at the direction of the regulators that weren't done, and that in and of itself could also be the basis of some sort of claim. So confidential supervisory information is oftentimes the most telling information that an institution has, but it's not available to the public. So we typically don't know. We don't know if there were any enforcement actions with either of these institutions, non-public enforcement actions. So those are things all that we just don't really have a sense of right now. And some of that may leak out eventually, but right now it's all confidential.
Thanks, Jeff. One of the other aspects is as we're looking here at the resource page, if anyone is looking for additional resources, we would also direct them directly to the FDIC's website, as well as the Federal Reserve resources page, where there's some more information on that bank term funding program. But Jeff, maybe we can open it up to Larry and Aaron, see if they have anything else to add. I know we're running a bit short on time.
Yeah, the only thing I'll add is on that last point, obviously, in addition to the FDIC looking at stuff, once you're in a bankruptcy, similar power is going to be given likely to a trustee or a creditors committee. And so you're going to probably see you're probably going to see increased investigations and things like that as well. A little bit different than some of the powers that FDIC has, and obviously different motivations. But I think as sort of was implied, that we're very much at the beginning of that story. Not even at the beginning. So it's going to be developing over the coming days and weeks and months.
Okay, well, I think we've said our piece tonight. We will be back tomorrow at 5:30 again. To tease it a little bit, I think we'll have a little coverage on the real estate side, and hopefully a little discussion around fiduciary obligations from a registered investment advisor perspective and what this takeaways from this may be from that perspective. So I would encourage folks to join us again tomorrow. Keep sending in the questions, and we appreciate your time, and have a good evening. Thanks, everybody.